Hello. Today we will be discussing the Nuremberg Trials, the criminal trials of the 22 most significant surviving Nazi officials after the Second World War. The trials marked the beginning of international criminal law as we know it today, and laid the foundations for such organisations as the International Criminal Court. During the Second World War, Nazi Germany infamously committed a significant number of war crimes and genocidal acts, such as the Holocaust. Therefore, following the conclusion of the war, there was a desire among many of the Allied powers to prosecute the high-ranking Nazis who were responsible. They recognised pretty quickly that whatever trial would come in future would have to be carried out by the Allies in order to prevent a repeat of the 1921 Leipzig trials. The Leipzig trials saw the Entente powers attempt to prosecute German war criminals after the First World War in front of the German Supreme Court. This attempt was largely seen as a failure, although it did still serve as a precedent from which to create a more comprehensive system for the prosecution of violations of international law. The Allies sought to learn from this experience and so issued the Moscow Declarations of 1943, which, among other things, expressed the desire of the signatories of Britain, the United States, the Soviet Union and China to pursue the Nazi leadership to the uttermost ends of the earth in order that justice may be done. And at the San Francisco Conference of 1945, US President Harry S. Truman announced the formation of an international military tribunal consisting of the United States, the Soviet Union, the United Kingdom and France. Now that there was going to be a trial, it now had to be decided on what the charges would actually be. See, they decided on 3 crimes with which to actually charge the accused: crimes against peace, crimes against humanity, and war crimes. The first charge, crimes against peace, prosecuted the planning, preparation, initiation, or waging of war of aggression, or the participation in a common plan or conspiracy to accomplish those acts. The second charge of crimes against humanity prosecuted the murder, extermination, enslavement, deportation, and other inhuman acts done against any civilian population, or the persecutions of that population based on political, racial, or religious grounds. And finally, war crimes were violations of the laws or customs set out by international conventions such as the Geneva Convention. These charges are what the Allies brought forth at Nuremberg, and additionally, in this photo here, we can see the Palace of Justice in Nuremberg, where the trials were to be held, mainly because it happened to be a large German building that hadn't been left as a complete smoking ruin by the war. The defendants were a mix of 22 of the highest-ranking German officials that had survived the war. These included many of the high-ranking generals, ministers, party officials, and propagandists that had actually made the Nazi machine run. This included such names as Hermann Göring, the fat one up here, who was the head of the Luftwaffe, the German Air Force, and previously Hitler's second-in-command. There was Martin Bormann, party chancellor and personal secretary to Hitler, who was tried in absentia and later found to have already died by the time of the trials. There was Karl Dönitz, head of the Kriegsmarine, the German Navy, Hans Frank, Governor-General of occupied Poland, Rudolf Hess, the mad deputy Führer who had flown to Britain in 1940 to personally hash out some sort of peace deal, Ernst Kaltenbrunner, the chief of the SS, Franz von Papen, former Chancellor of Germany and diplomat, Joachim von Ribbentrop, Nazi foreign minister, and Hjalmar Schacht. Next, the former finance minister who had actually been arrested by the Nazis toward the end of the war, Albert Speer, the Minister of Armaments and Hitler's personal favourite architect, and more. All defendants naturally entered a plea of not guilty upon the commencement of the trial. The 4 powers taking part in the trials each carried out their own separate prosecutions, each of which would usually focus on some different component of the allegations being brought forth. The Americans, led by Supreme Court Justice Robert Jackson, sought to prove that there had been a Nazi conspiracy to commit crimes against peace and humanity before the war. This part of the prosecution was hampered and became derailed by the disorganised presentation of the evidence and by failing to specifically tie it to each of the defendants. The British, led by Attorney General Hartley Shawcross, stood a bit better as they whilst they also focused on crimes against peace, they mainly focused on citing the numerous treaties that had been broken by Germany and the complicity of the German armed forces and Foreign Office in the charges. The French prosecution, led by François de Menthon, focused on the charge of crimes against humanity and delved into Germany's development as a nation and argued that Nazi ideology was the criminal intent of the crimes on trial. And finally, the Soviet prosecution, led by Roman Rudenko, focused on the charges as a whole and on the destructiveness of the German invasions throughout Europe. Now, after the prosecutions wrapped up, the defendants were given the opportunity to actually defend themselves in order to both ensure genuine justice and prevent accusations of Nuremberg simply being a show trial. This was the most famous portion of the proceedings, in particular due to what has since become known as the Nuremberg defence. The Nuremberg defence is the term used to describe when the defendants at Nuremberg used the excuse that they had been simply following orders, even when they had actually been the ones giving the orders in the first place. This leads into the other main defence, which was that the defendants mainly blamed just about every crime and failure of theirs on Hitler, Himmler, Goebbels, or some other Nazi who was too busy being dead or Argentinian to defend themselves. And finally, there were constant attempts by the defence to discredit the trial, calling into question the very authority and procedure of the proceedings. This was resolved, in part, by allowing the defence freedom with regard to its witnesses, although some of these would actually end up hurting the defence case and supporting the prosecution's case. And whilst the defence was largely ineffective, there were still some successes, such as Admiral Karl Dönitz escaping the charges of war crimes for his order to abandon or kill the survivors from sunken Allied vessels, since that order had come in response to the Laconia incident, in which had seen a fleet of American naval bombers attack a U-boat which had actually been conducting a rescue operation for the survivors of an ocean liner it had sunk. After the prosecution and defence had their turns, the judges came to a verdict. They decided that aggression was the most serious of the charges because, in their words, war is essentially an evil thing, and furthermore ruled that there had been a premeditated conspiracy by the Nazi government to commit crimes against peace with the goal of disrupting the European order and furthering their pan-German ambitions. And as such, the charge of crimes against peace effectively led into all the other charges. As for the defendants, 12 were sentenced to death by hanging, including Goering, Bormann, Ribbentrop, Keitel, Jodl, Rosenberg, Kaltenbrunner, Salkel, Streicher, Seyss-Inquart, Frank and Frick. And Bormann had already committed suicide during the fall of Berlin, while Goering popped a cyanide capsule during the night before the execution, so he was already dead as well. And then 7 of the defendants were sentenced to life to imprisonment in the Spandau prison in Berlin, including Hess, Speer, Dönitz, Raeder, Schirach, and Funk, and Neurath. Hess would be the last living member of this group, and his life imprisonment would actually go on to inspire the name of the band Spandau Ballet. Finally, there were 3 acquittals, including Schacht, Papen, and Fritzsche. The acquittals were particularly surprising to outside observers, and mainly arose from deadlock between the judges, and also played a significant role in legitimising the trial in the eyes of the German people as well. So the impacts and legacy of the Nuremberg trials are widespread and is still hotly debated to this day. The main trials were going to be used as sort of the template for a series of further trials pertaining to the SS death squads known as the Einsatzgruppen, Nazi judges, Nazi ministries, and German corporations including IG Farben and Krupp. It would also serve as the basis for the Tokyo trials, which prosecuted Japanese war criminals. These subsequent trials also became the first instance of the word genocide being used in a legal context, to define the deliberate destruction of a group of people. The trials were also a technological leap forward for simultaneous translation, as this had to be figured out in order to organise a trial which would be conducted in English, German, French and Russian all simultaneously. On one final note, the man pictured here is Benjamin Ferencz, the last surviving prosecutor from Nuremberg who passed away in 2023. So, overall, the main impact of the trials is that it acted as a significant milestone in the development of international criminal law and international cooperation, and perhaps most importantly, it created an avenue with which to prosecute foreign war criminals, even extending to the level of heads of state, such as President Milosevic of Yugoslavia, who was prosecuted for war crimes in the 2000s. Thank you all very much for watching. Please like, comment and subscribe if you liked the video. If you have any further questions about this topic or any topics that you'd like me to cover in future, please leave them in the comments down below, and I will see you all in the next video. Goodbye.